To the podcast. Rakesh Kilaru, thank you so much for coming back on.
Thanks, Gabe. I got to say, you've upgraded to video. And so I thought this would be an opportunity to showcase the smoking jacket that you promised me on past appearances, but maybe next time. We'll see.
Your jacket is really, it's a stylish, you've got like a little Miami Vice look going.
I'll take it. I think that's a compliment.
Definitely a compliment. Definitely a compliment. This is your sixth appearance.
Wow.
You have now set a record. I think you'd already set a record, but now you've cemented your record. Let's set the table a little bit because the house settlement itself is very complicated. As you know better than anybody, was subject to pretty intense negotiation. And let me summarize what I think is the general framework that came out of the house settlement. And then you can confirm or tweak that. And then we can talk about the challenges to the settlement. All
Sure.
right.
That sounds good.
All right. So we had the back damages, which we're not going to talk about now, but the back damages that are going to be apportioned according to a formula put together by the plaintiff's economists. But really, the big focus is on the forward looking changes, the injunctive relief that did a lot of things. But for our purposes, it allowed schools to share a portion of a category of revenue directly with the athletes. And that's our $20.5 million ish this past year. And then it also allows college athletes to do NIL deals as long as those NIL deals are not used to circumvent that cap, as long as they are legitimate NIL deals, because they wanted to give college athletes the same NIL rights as all other students on campus. And so there was an enforcement mechanism set up or designed to prevent these NIL deals as being used to circumvent the cap or being an end around to undercut the crux of the settlement, which was to put a limitation on, again, among other things, how much schools could pay the athletes directly. So provide direct compensation, but provide limits on that for a variety of reasons. Is that a fair assessment of that portion of the settlement?
Yeah, I think that's fair. As you said, there's a lot of reasons you have that cap, and I'm sure we'll talk about some of them, but salary caps of some sort or another common features in sports leagues. There's good reasons for that, but you have it right, basically.
Okay, so it's designed in some ways to mirror a pro sports league system where there is a cap and there are very strict anti-circumvention provisions to prevent exceeding the cap. And those are, we all know, those are collectively bargained. This is the result of the settlement. And I think we all assumed there would be some debate and discussion and disagreement about what the settlement means, because that's what happens when you have a settlement like this that impacts this many parties. And we are now on the eve of a hearing in front of a magistrate judge over a dispute regarding the definition of associated entities and where MMR partners and third parties fit in there. And as part of this settlement, it is pretty clear that if an associated entity is doing a deal with an athlete, then those deals are subject to heightened scrutiny to ensure that they are for a valid business purpose and that they are for some dollar amount that is in a range of reasonableness. People refer to it as fair market value, but a range of that. And the issue that has popped up in the Nebraska case was whether Nebraska's MMR partner, the warehousing deals they had done, would be approved. They were rejected by the CSC, sent to an arbitrator, affirmed the rejection of the deals. And now we have this separate hearing in front of the magistrate judge. And one thing I want to clarify, and then I'll stop talking and let you come on, is you do not represent the CSC. You did not represent the CSC in that arbitration. They had separate counsel, but you are representing the NCAA in this motion to enforce the settlement, where the plaintiff's counsel is arguing that the definition of associated entities has been too broad and it captures MMR partners and should not, and those deals should not be subject to scrutiny. Is that all? Have I said all of that fairly?
Yeah, I'm not sure you need me. You kind of got this down so far.
So, all right. So thanks for coming on, and I'll see you next time. So Tell us now what has the heart of the dispute, because there are a few different claims that are made just in reading the briefs. There seems to be a little bit of disagreement about what the disagreement is about, but if you could sum up the heart of the issue, that will be before the magistrate judge.
Yeah, for sure. And I guess I'd start kind of similar to where you started, which is I don't think it's necessarily surprising that a dispute has arisen over the meaning of the settlement agreement. Like you said, we it's a long settlement agreement. It was designed to anticipate what might happen over the course of 10 years, but 10 years is a long time.
Right.
And it was a new system that was being built. Like I said, it's not surprising that these types of disputes arise. As to this specific dispute, it essentially comes down to two things. I think the way the plaintiffs phrased it is one thing, but I actually think there's two things that are going on here. And the two things are first, does it make sense to just say that these entities called MMRs or multimedia rights organizations are just categorically exempt from this category of associated entity and individual? That's sort of one question. And then a second question, and this is the one that we put more into the ballpark, is and should the court be deciding that? Or should the arbitrator be deciding it through the process that went through in the Nebraska case? And where I think the disagreement comes from on the first issue is there's this definition of associated entity and individual in the settlement. And everyone agrees that when we started with the settlement process, we had initially phrased the concept of who gets extra scrutiny. And to be clear, the scrutiny doesn't mean a deal is not going to go through. It could be that there's a deal with an associated entity and individual, and it clears the checks that we negotiated with class counsel, and the student athlete gets to go forward with the deal. So the fact that it goes through scrutiny doesn't mean the deal is not going to happen. But we agreed on this originally, this concept of booster in the NCAA rules, which was it turns out an extremely broad term. We lay this out in our briefs, but boosters, as defined originally under NCAA rules, there's a technical term for it. It wasn't booster, but it's incredibly broad. It could include people who had bought season tickets to a football program. It could include anyone who'd made any kind of donation to the athletic department. So we put that in front of the judge, and Judge Wilkin was a little worried that was too broad of a definition. So we came up with this concept of associated entity and individual. And the goal there, as you said at the beginning very well, was to try to capture the types of transactions that were most likely to be efforts to circumvent the cap that we had negotiated. And if you think about this in other contexts, like if you think about it as the Kansas City Chiefs, it's not the Kansas City Chiefs pay Patrick Mahomes a ton of money. But if there's a rich guy or a rich girl in Kansas City who's, hey, I love Pat Mahomes, I'd like to pay him an extra $50 million, that's not allowed. That rich guy or rich girl can say, hey, Patrick Mahomes, we want to hire you as a sponsor for our car dealership or what have you, and you'll do a legitimate promotion and we'll pay you for that. That's fine. But the first thing, just like extra money to play for Kansas City, it's not allowed. And the reason it's not allowed, as you said, is simple. If you have that, you're not really going to have an effective cap system. And if you don't have an effective cap system, you don't get the things that you want with a cap system, which are some level of competitive equity. The teams on the field are spending or able to spend the same amount of money on their players. And also, I would say in the college sports context, this idea of spreading opportunity across an athletic department. One of the things that was a feature of the old system before revenue sharing is that there were extremely broad athletic department offerings across campus, tons of sports, facilities that benefited all student athletes. And the goal was to allow additional compensation to student athletes, but in a way that kept some of those features still in place. So that's a long way of saying we negotiated this term associated entity and individual, and it's actually, because lawyers are lawyers, a 5-part definition that has a bunch of different categories that are somewhat overlapping, somewhat not. But the goal really was to try to figure out what's a category of transactions that should get extra review to make sure that there's not an effort to circumvent the cap. And our view is the definitions are what they are. And in certain circumstances, depending on the facts, a multimedia rights organization could be an associated entity or individual. And we kind of know that's the case because, as you said, there was an arbitration recently where one of these MMRs tried to get deals through at Nebraska. And the arbitrator in that case found, looking at the plain text of the settlement and the facts in front of him, that the MMR in that case was an associated entity or individual. So our position in the litigation and the dispute is you have to decide this on a fact by fact or a circumstance by circumstance basis. I think class counsel have come in and said just categorically MMRs can never be associated. And I think there's some problems with that categorical ruling, but probably the first and foremost problem is that there isn't an MMR exception to the associated entity and individual rule. It's a rule and you apply it to individual facts. The second issue, which we've raised, is who decides this question? And the class counsel have taken this position that under the settlement, they can pretty much always go to the court and get a judicial ruling whenever they want. And we've laid out in the briefs that actually on this specific issue of whether a transaction involves an associated entity or individual, this is actually something that needs to get resolved in arbitration. So as part of the settlement, we worked with class counsel and built a new arbitration system. And this was intended to be a feature of the new system. Okay, the idea was before you had NCAA enforcement staff working in Indianapolis, and obviously they're my client. I think they did a good job, but there are concerns that people have about whether that process is transparent, how it works, et cetera. And so we agreed that if there's a dispute over certain things under the settlement between a student athlete and an institution on the one hand, and the enforcement entity, the CSC in this instance on the other, that those should go to a neutral arbitration, and there should be a group of arbitrators who are picked by us and the plaintiffs working together, and they decide those issues. And at least we think the settlement is very clear that this question of whether a specific entity is associated or not, that's something that goes to arbitration. The CSC makes a decision. It's not final, goes to arbitration. Arbitrator will decide. And again, I think the Nebraska system shows, the decision, shows that this system works. The arbitrator looked at the facts there and made a decision. And from our perspective, if instead of having the arbitration process work, every time there's a concern that CSC is looking into an entity to determine whether or not it's associated and trying to get some facts to figure that out, if every time that happens, class counsel can rush to court and get a ruling, kind of what's the point of the arbitration system? What's it there to do? So we built that for a reason. This is one of those reasons. And so our position is we should kind of let the settlement work as drafted. And obviously they disagree with that, but I think that's the crux of the dispute that's in front of the judge. It's who decides whether someone is an associated entity. And then second, are there these groups of organizations that are just categorically exempt from being associated?
So let me ask another question that also seems to be lurking beneath that I think you identify in your brief is what if they are not associated entities, then let me back up. There's seems to be a little bit of disagreement on what level of scrutiny applies to the just everybody who's not an associated entity and then who is an associated entity. And seems like one way to characterize it is that the associated entities get a heightened scrutiny, but everybody else still gets scrutiny. Or, as the plaintiff seemed to suggest, that there's only scrutiny if you're an associated entity. Otherwise, the deals are automatically approved. And that's the sense that I got from reading the brief. But so let me ask you, what if they are not associated entities? What is the review process at that point?
Yeah, so I think it's a slightly different dispute. I think you're right, there's a dispute, but I don't think it's quite the way you phrased it. I think we agree that if an entity is not associated, then the deal goes through, right? It doesn't go through these other boxes of, as you said, looking for range of compensation review, of looking for whether goods and services are being provided to the general public, et cetera. It doesn't go through that. So you do have what you would call legitimate third-party NIL deals. Those need to be reported into the system for a variety of reasons. But if they're reported, they're not associated, then the deal goes through. What I think the dispute is about is over whether and how CSC can investigate whether an entity is associated or not. And the position that the class counsel are taking in the case is CSC should basically have very limited authority to investigate that. And more specifically, in the context of an MMR, they should never be allowed to investigate that. They should treat the MMR as a deal from a completely unaffiliated, pure third-party sponsor that comes to the school and says, hey, we just want to sponsor your student athletes. We're not boosters. We don't work with your athletic department. We don't have people on your campus. We're not talking to the coach about who should get the deal or not. We just want to do a sponsorship deal with athlete X or Y. And so the dispute really is about the degree to which the CSC can investigate an entity to determine whether or not it's associated. And this is where you have this sort of chicken and an egg problem. Of course, if you just categorically decide someone's not associated, then they're not associated. But whether or not someone is associated really does depend on whether they fit into one of those five categories that we talked about in the settlement. And the only way to figure out, in some instances, whether they fit in those five categories is to figure out what they're doing. Because some of the categories involve things like, are you actively working with the recruiting and retention of student athletes on campus? If the organization's doing that, then they might be associated. If they're not doing that, they're not. But you can't just make that decision, at least from our perspective, in the pure abstract, particularly given Brian Seeley, the CEO of the College Sports Commission, issued an affidavit in the case that's evidence as part of the record. He just said, look, these are some of the things that we as the CSC are seeing when we look even at just this category of associated entity. And some of those fact patterns, like people embedded on campus, working with the athletic department, what have you, those are things that we think we need to be able to look into and may make you associated depending on the facts of how that operation is occurring.
Okay, so let's talk about that a little bit more because the as you mentioned, there was an attempt to just take the booster definition and language that the NCAA has used for decades, and there was a pretty clear understanding in general of who a booster was. But then it, as Judge Wilkins said, this seems just wildly broad and seemed like it could include people that you don't necessarily want to exclude and that it would have a significant impact. So again, that's why you came up with that very complicated associated entity definition. But I think it's fair to say the main target of that was the traditional booster and collectives that had popped up that were created with the sole purpose of providing money to college athletes, right? And now they may say it wasn't our sole purpose. We had other things we wanted, but they were not, and this is part of the definitions, they were not selling a product. They were not a for-profit company that was trying to use athlete NIL to promote a business or get a return on investment. They were just trying to, and you can say this is totally fine what they're doing, but what they were doing was trying to get athletes to come to a particular school or stay at a particular school. And that, like you said, if that would be a fan of the Chiefs just saying, hey, I'm going to give an extra $1 million to Patrick Mahomes because I want Patrick Mahomes to stay here, that those were the target. And then it's all right, an MMR partner is not that, right? Learfield and Playfly already existed. They do have a for-profit business. They are trying to make money. They are trying to promote their business. They are trying to get more schools to sign on. And so the part of the plaintiff's argument is a booster is someone who is just supporting a single school, and that's their only purpose. And MMR partners are at many schools, so they cannot be a booster. And your response is you're cherry picking one of the definitions of associated entity in the agreement. So can you explain that? Because I think a lot of people just instinctively say, yeah, an MMR partner is not a booster. Learfield's not a booster. Learfield and Playfly have been working with schools for years and they have a real business. And why would they give all of their money to Wisconsin when they're also working with Nebraska or whatever the school might be? So explain, because it's, again, if it just applied to traditional movie style boosters, the Buddy Garrity
Buddy Garrity,
from,
of course.
yeah, Buddy Garrity, then I think Learfield would say we're not Buddy Garrity, and you would agree
Yeah.
that they're not Buddy Garrity, and yet there's still an argument that you have an argument that you don't have to be Buddy Garrity. So what else? Why is MMR? Why are MMR partners, from your perspective or from the settlement's perspective, associated entities?
Yeah, so I think a couple things out of that. The first I would say is, at least my understanding of it is true that MMRs like Learfield and Playfly have been around for a long time operating on college campuses. I don't know that there can be much dispute that they're operating differently now in this world where there is NIL that's allowed to be provided directly to student athletes from schools and where there's more general third party NIL out there. So I think the fact that in the past they may have operated in certain ways doesn't necessarily mean that that's how they're always operating. And if they're operating differently now, that's a different circumstance, which is why we think you have to look at facts and circumstances. The second thing on this is it is certainly true that when we set out to negotiate who would get this extra scrutiny, one thing, maybe the foremost thing on folks' minds were these collectives, right? Which were these organizations that kind of came out of nowhere that didn't exist basically after July 1st, 2021, when the NCAA first relaxed its NIL policy. You had these organizations spring up and they said, hey, we're doing NIL. But everyone knew that what they were actually doing was just like amassing money together from donors and then providing it to specific athletes that the coach or the athletic department wanted to have on campus. And so that was definitely a concern for the reasons we talked about earlier. That's like the easiest example you can think of a way to circumvent any salary cap, whether it's zero or whether it's $20.5 million. But one thing that I will say we were smart enough to realize, I give us a little bit of credit for this, is that we were not going to be able to predict every way that money would try to flow to student athletes to circumvent the cap. And I think in the past, there had been efforts to try to, like, I think one of the reasons the booster definition was so broad and complicated earlier on is that basically what happened is the NCAA kept adding to it every time there was a new factual circumstance that came up. So at the end, you have this definition of booster that covers dozens of different types of groups. We thought, hey, these collectives are a thing right now. People out in the market are creative, right? And there may be different ways that people come up with to try to figure out how to circumvent the salary cap, circumvent the revenue sharing structure. And so that is why the definition is phrased the way it's phrased. The first two definitions, and I don't have the specific words in front of me, but I think it's fair to say those are somewhat targeted at what you might call the classic collective, right? Which is an entity that exists to support a specific school's athletic department. But there's other parts of the definition and other parts of the definition. I think the one that's perhaps the most important for these purposes is pretty much any organization that's involved with recruiting and retaining student athletes. Because if you're involved in recruiting and retaining student athletes, that raises the concern that your payments are being made to recruit and retain student athletes as opposed to for third-party NIL. So that part of the definition is in there as well. And what I think is really odd about this dispute when you read the brief that the other side has filed is they kind of want to have boosters both ways. Like they say, hey, associated entity and individuals is really narrow because we started with this broad definition of boosters and then we shrunk it down. But then in the same breath, they're saying, and also associated entity individuals is really narrow because it only covers boosters. And like both of those things can't be true. Like it can't be that the term is really broad and really narrow. And I think the truth is in the middle, which is to say, yes, the definition was intended to be broader than booster is, excuse me, narrower than booster as it was originally phrased. But the flip side of that is it was also intended to be broad enough to cover efforts to circumvent the cap because that was the thing that we wanted to make sure there was authority to do.
And do you think part of this is then this sort of transposing the booster language and concept from pre-house and pre-NIL into a post-house world where in the pro leagues they don't use the language of booster or associated entities. Theirs is a broader anti-circumvention provision. If the deal is being used to circumvent the cap, then it's going to be prohibited. And then there are factors that go into whether it's being used to circumvent the cap. But that's what this is at heart is about. It's less about whether someone is a booster or not. It's just whether this is being used to circumvent the cap because that brings in, I think at least the third parties, the apparel companies who, again, no one would say that they qualify as a booster, but they might meet the definition of associated entity or be looped into it depending on the school's involvement with them and whether they've been the school has attempted to do the deal. And again, I don't have the language right in front of me, but is that fair to say that this is, I get it, college sports is a booster based world and the boosters have been the ones who have paid athletes under the table in the past and now are paying them over the table, but maybe there's another table so it's still under the table. I don't know. Or maybe the tables are gone, the but is that fair that this is really just this is an anti-circumvention provision and the radar goes off or the red light goes off if it's an associated entity because they're more likely to be circumventing the cap?
Yeah, I think that's what it was designed to get at, really, which is really this focus on circumvention and really this focus on deals that are not actually for NIL, but are for something else. And that was the concern that we set out to solve in terms of retaining some regulatory authority over third party NIL. And I'm sure that if you had asked before the negotiations, the plaintiff's view would have been there should be no restrictions whatsoever on third party NIL. But I think we, from our perspective, realized that won't work for this very precise reason. And as you said, it is this unique thing about college sports, and it might just be because in other leagues, there's been one league for a long time, and so they agree on a set of rules that applies to that one league, whereas the NCAA is a membership association, and there's different conferences, which you could think of as leagues, and they're working together in this structure. And frankly, there, as you said, is just a different culture in college sports historically, where there are, frankly, rich folks who really like to be associated with the school or the team, or the school and the team is the way through which they show that most demonstratively. And so you have to figure out how to recognize that those people are important on college campuses and have a lot to contribute, but also have it operate within a league structure that actually makes sense. You don't really have, I guess you may have rich super fans of professional sports teams, but they just know what the rules are. And so they spend their money in other ways, like buying luxury suites or what have you.
Okay, so let me ask you one more question about the MMR partners, and
Sure.
then I want to ask you about the apparel companies. But if it let's say it's Playfly and Nebraska because that's the subject of the arbitration. If they are an associated entity, as you said, that doesn't mean the deal is rejected. It just means it has to pass that heightened scrutiny, or I think of it as just a scrutiny because there is no scrutiny if
Yeah.
they're not an associated entity. So they have to pass that test, and then that's again up to the CSC to make that determination. And then if the athlete or the school disagrees, they can bring it to arbitration. Then that's supposed to be final and binding arbitration. But if they are not an associated entity, then the deal goes through. So, what is an example of how Playfly would not be an associated entity?
This one I'm going to cheat on and just
Yeah.
say, look, if their activities don't fall within the definitions, this is the thing. Like part of our position, actually, the core of our position is that there aren't really categorical rules for this. You have to look at the circumstances and whether they fit into those five categories. And are the five categories crystal clear and precision? Probably not. But I do think that someone can look at those categories, they can look at a set of facts, and they can reasonably decide if it falls within that set or not. And the structure we agreed on is that the CSC would kind of get the first right to do that as part of the system. And then if there was disagreement with that, any student athlete or an institution subject to the terms of the settlement can go into arbitration and say, we want someone else to look at it. And you kind of live or die with those results, right? I think
Right.
the thing that is, I would say, somewhat, I don't know if you, I don't know what word you use, so maybe I'll just default to the very pat interesting. I think it is interesting that this motion to enforce was filed days before the first arbitration decision in this process. And then lo and behold, the arbitration decision came out to say that the organization was an MMR. There's something interesting about that timing, to say the least. And
Was an
this is
associated entity. Yeah.
exactly, yeah,
Yeah.
exactly.
Yeah. And so what? All right. So let me ask you the other side of the question then. What I know I can anticipate your answer is going to be if they meet one of the five definitions, but what would it be an example of how a MMR partner would act as an associated entity, as opposed to just being a traditional partner that's doing what they've always done, or what
Yeah,
they've done.
I unfortunately am going to give largely the same
Okay.
answer. And I
Okay.
think there's a couple of reasons for that. One, I would say is really kind of not for me to say. I mean, I
Yeah.
think the settlement says what it says. And under the settlement, this decision has been committed to the CSC and to the arbitrator. I will say, if you look at the Nebraska decision, one fact that's probably a good one for an entity being an associated entity is if they say they are an associated entity. That was one of the many facts in the Nebraska decisions. But
Yeah.
even the organizations can look at the decision at the definition and say maybe that applies to us, maybe it doesn't.
Yeah. And so then I assume the same answer for a third party, an apparel company that, again, most people thought that this is just a publicly traded company that is clearly selling shoes or gear, and they have deals with lots of schools, then their deals wouldn't be subject to scrutiny. And yet, under the definition. So if a third party has been directed or requested by a member institution's athletics department staff to assist in the recruitment or retention of prospective or current student athletes, that makes them an associated entity. Is that intended to cover the situation where a school says to a, and let's just make up an apparel company, let's call them Adidas. If a school reaches out to Adidas and says, Adidas, we really want Joe Smith, probably shouldn't use Joe Smith because he was one of the players who was actually involved in some of this cap circumvention stuff
It's
with the
actually a
NBA.
really, it's a funny
But
analogy or a funny
yeah,
example.
yeah. But if they wanted to, if the school said, "Hey, apparel company, we really want Joe Smith. Can you give him a $2 million NIL deal?" That what makes that apparel company a an associated entity?
It could. I think, again, it really comes down to, sorry, I'm going to be boring here. And so, not, maybe this is funny in its own way, but it comes down to those definitions. But I think
Yeah,
here's one thing I would say that is a backstop to this. When you have a company like, I think they're probably publicly held. I could be wrong on that, but just assume you have a publicly held company and they have a
yeah,
board and they have shareholders and they have to be responsible to those shareholders.
yeah,
Maybe they're associated under the settlement, but the odds that they, I would say in theory, the odds that they fail scrutiny are probably going to be lower because if you're a profitable, successful company, you're probably not going to say, hey, let's give some way above market deal to a student athlete to promote our product. You have to defend that to the people who run your organization, to your board, et cetera. So I think it's fair to say it's more likely you would be making deals that actually make economic sense, in which case there shouldn't be that much of a problem with clearing associated entity status. And again, I don't know about the specific facts of any individual case because that's being done by the CSC. That's
yeah,
maybe why some entities say, look, treat us as associated. We don't need to do an investigation. Treat us as associated, but then the deal is going to be fine. So let's go forward.
yeah, yeah, and yeah. So it really then just becomes a factor in the scrutiny that CSC would do that, yeah, technically Nike fits the definition of associated entity, but it's Nike and they're not in the business of just giving out cash to athletes to direct them to particular schools, although maybe in the past. But putting that aside, that's for the arbitrator or for the CSC to then say this is for a valid business purpose because they're promoting Nike's brand and it's in this range of compensation. And again, and then if that's rejected, the backstop is the arbitrator, and it goes back to your original point, not to go back to federal court to basically undo this provision, right? And so that it seems to me that, and you argue this in your brief, that this is not something the court should be deciding at all. And even if they are to decide it, here's why they should decide in our favor. But let's say you lose. Let's say Magistrate Judge Cousins says no categorically. MMR partners cannot be associated entities, and these deals just start flooding into the system, and it looks from the outside like the cap is no longer a cap because MMR partners can now just spend money on athletes, and it's pretty transparent what's happening. What happens at that point where it feels like they've undone the crux of the settlement?
Look, it's a good question, and I certainly don't purport to have all the answers. Obviously, I would hope and suspect that's not what the judge rules. But kind of taking your example on its own terms, legal process wise, I'm sure there will be avenues to appeal explored by both sides of that decision, and that's potentially an opportunity that's available to both sides. Practically speaking, I'm not sure. I do think that is, we've said in our brief, obviously, that's not what we intended when setting up the settlement. It's not the result that a categorical exception for this group of organizations is really not what was intended. So I don't know exactly what would happen in that circumstance. I will say that there are mechanisms in the settlement for passing rules to avoid circumvention that then go through a different type of judicial process. So maybe that's an approach that could be deployed. Beyond that, it's a little hard to say, but I
Yeah,
think we kind of have to take the decision and then go from there.
yeah, and I won't ask you, but I'll just say: is there a scenario where the settlement falls apart because you made it pretty clear, and the NCAA made it pretty clear that this was a key part of the settlement, that there had to be some limitations because that's why you were settling, is whether you call it for competitive equity or just spreading out the money or however you want to characterize it, that this was a key part of it. And I believe as Judge Wilkins said, why are you restricting any compensation at this point? And so if there's really no ability to restrict it. Again, maybe this is a rhetorical question. Does the settlement continue, or is there an effort to undo it or change the system?
Yeah, I think there's a couple different ways to look at that, and I won't have an ultimately very satisfying answer to it. I will say that part of a settlement process and part of agreeing to go this route of having a court enforced settlement and a court enforced injunction to resolve this case is you have to take the good and the bad of the court enforcing the settlement. I also think, and this is maybe more in response to rumors that are out there about will the settlement, will people break away, that sort of stuff. A settlement agreement is a contract. And it's a contract not just between us or the NCAA and the plaintiffs, it's a contract between all the defendants and the plaintiffs and each other. And that was carefully negotiated. Everyone sat down together. They came up with this set of rules. They came up with this way of handling things. They came up with a structure where I know we don't really need to talk about it, but there was both going to be an injunction going forward and damages payments going backwards, and they all kind of work together. And so it's not something where I think generally speaking, someone can just say, I don't like it, so I'm out. That's kind of not what happens when you sign a contract, basically.
And then when what's the expectation in terms of timing of a ruling? Has Judge Cousins given any indication of whether this is going to be from the bench or quickly soon thereafter?
I don't know is the answer as far as an indication. We have the hearing on the 10th, and I'm sure he knows that this is an important issue and that it has consequences for how the system operates, but I'm also sure he wants to get it right. And so exactly how that washes out, we don't know. But I guess maybe we'll find out together on that one on the Zoom.
And is Judge Wilkin still active, or do we know?
As far as I can tell, she's still active. I don't know that there's sort of many cases on her calendar at this point in time, but she's
Yeah.
still the judge of record. And a couple months, for example, we're going to submit our papers for how the notice process will work for next year, because every year new student athletes coming into the system get notice, and we're planning to submit that to her. So
All right, then okay, a couple other quick questions. The Fontenot case that's still floating out there. What's the for those who don't know, Fontenot was basically a mirror image of parts of the House case where athletes who either opted out continued a similar lawsuit in Colorado. Where is that?
So it is kind of moving its way through the courts somewhat slowly, as is the case with kind of big civil cases generally. So, as you said, that lawsuit is, I think the best way to think about it is it is a bunch of individual lawsuits that are kind of batched together for management purposes. You have roughly 300, it's more than 300, but ballpark 300 individual student athletes who chose to opt out of the damages portion of the settlement, which is to say they looked at the offer that was given to them under the settlement and said, we don't want to take that. We want to pursue our own claim individually. And 300 of those folks, there were roughly 400, which is a pretty tiny percentage of the overall group, but about 300 of them have grouped together in this case called Fontenot, and it's being litigated in the district court in Denver, Colorado. We've entered some orders that kind of schedule the case. The scheduling orders basically take up the vast majority of the rest of this year, the year after that. Civil cases are, generally speaking, they move slowly. In this one, you have a lot of plaintiffs. You have to look into the facts and circumstances of each plaintiff. Each plaintiff is going to have their own view about how much money they should receive relative to the settlement. So it's going forward. It's going forward slowly. One important thing to note, which I think we've probably talked about before, but that is a damages only case. So the Fontenot plaintiffs, they can opt out of the damages. They can say, we don't want to take the money that's being offered to us under the House settlement. They can't opt out of the injunction. The injunction is in effect. You can object to it, which people have done. I think they objected to it at one point. They haven't come back to object to it in later years. But the injunctive piece, that's in front of Judge Wilkin. It's up on appeal in the Ninth Circuit. That's not something that would get addressed in Colorado.
Got it. Okay, and then last couple of quick things. The the eligibility disputes in a nutshell. Give me an update on the eligibility disputes and the potential new NCAA rule.
Yeah, I feel like I'm probably gonna have to do this a little quicker. I know you had a whole podcast on this with one of my adversaries on the other side. But look, the long and short of it is the NCAA has had eligibility rules for a very long time. And every sport has eligibility rules. Little League, you can only play in it until a certain age, right? U20 soccer, you can only play in until a certain age. For a long time, the way the NCAA has structured eligibility rules is to basically say you get 4 seasons to compete in college sports because college sports is played at institutions that are 4-year degree granting institutions. And for a long time, the rule has said you have to do those 4 years over a 5-year period. And the thought process behind that was you should have 4 seasons because that's how long it typically takes to get a college degree. But things can happen, right? You can get injured or you could have a season not go maybe how you wanted it to go. And so 4/5 was the concept. And that's been the rule in place for a very long time. And for a very long time, no one really questioned that was a rule that made good sense. And starting with after the House settlement came into effect, and in this world in which there were potentially large sums of money that student athletes could get to play in college, one student, Diego Pavia, and now many others, I would say dozens of others, have come to court to say, hey, these eligibility rules are an antitrust violation. They restrict me from continuing to earn money to play college sports. And so I should get a preliminary injunction, which is basically a court order to say, immediately grant me relief, let me get on the field, let me get the money. And typically what would happen is at the end of the year, they would say, okay, I got what I wanted, so the case is over, let's move on with our lives. Stepping back, I would say what I think has happened over the last year is more and more courts realizing that this is not an antitrust issue. Okay. Antitrust laws, as you well know, are a specific type of law that's designed to affect and address issues affecting competition, right? Competition in a workplace, competition in a marketplace, competition generally. They are not laws that are designed to remedy every situation that a person perceives as unfortunate. And I think it is totally fair. And we have said this in briefs, we've said it at argument. We understand that if there's a student who is earning money and playing college sports and they want to keep doing that, it is probably unfortunate for them if that comes to an end. The flip side of that is almost every one of these student athletes, when we've had a chance to ask them questions in the cases, has talked about how that progression of coming in as a freshman, of earning your spot on the team, of being part of a team has been instrumental to their growth as a person. And when someone stays for an extra year, it means someone else doesn't get that opportunity to be a first year at that school. And so what I think has happened over the last year is more and more courts are actually asking the question, is this a problem or is this an antitrust problem? And if it's an antitrust problem, then you can have a lawsuit and you can go to court and you can have discussions about that. But if it's just a problem generally where one person is unhappy with outcomes, that's not an antitrust problem because that's not a problem with there not being enough competition. It's a product of you having a set of rules that says that certain people can compete for certain periods of time. So there have been a bunch of court of appeals that have addressed this issue over the last few years, or the last year, I would say. And pretty much every one of them has said, look, if you want to come in and say that these eligibility rules are a problem, you need to actually make out the benchmarks of an antitrust case. You need to show that there's some market that's being restrained. And then you need to show that there's harm in that market. And you have to bring forward that evidence or we're not going to give you a preliminary injunction. And I think it's telling, if you look at these cases closely, that you have different groups of student athletes bringing lawsuits. So sometimes you have folks who competed in junior college and they say, those years shouldn't count. I should get 4 years of Division I experience. Sometimes you have folks who competed in NAIA schools, which is a different athletic association. You could have people who competed in Division II and they say that shouldn't count. Only Division I should count. And then you have this different group of people who say, I competed for 4 years in a row and I should get a fifth year. It's not fair that I don't get a fifth year. And kind of every one of these groups is saying that the market is different, right? In the junior college case, they say, oh, we're in the market. In the 4 years and 5 case, they say, oh, junior college isn't in the market. And if people are constantly changing the market to fit their individual facts and circumstances in something that we all know is a thing, which is college football or college basketball or college sports, it's probably a pretty good sign that there is an antitrust issue. Now, maybe a very long wind up here, but to answer the last bit of your question about the potential new rules, there has been all this litigation. And we, I think, do stand by the rules. I think the rules have been successfully defended in the vast majority of antitrust cases. But there's also been this other set of cases that are cases about waivers, right? So the NCAA has this very long system of waivers in place. And I should say, It's not like people in Indianapolis just came up with these rules. Like I'd say this every time I talk to you, so I know you're tired of hearing it, but the NCAA is a membership organization. Like when rules are in the rule book, they're there because schools want them there. Okay, what the NCAA does in Indianapolis is facilitate the process by which the schools can come together and pass rules that the schools want to have be in place. But that process has resulted in a very long and complicated set of waivers that student athletes can use to try to get an extension to their 5 year clock or an additional season above the four. And those cases, those rules have created a new type of lawsuit, which is a student coming in and saying, so and so got a waiver and I didn't, so I should get a waiver too. And this new potential set of rules that's being evaluated, it's we think it makes total sense from an antitrust perspective. It makes intuitive sense, but I think it's fair to say it's also designed to try to address some of these persistent issues that keep coming up with litigation. And the idea would be to move to a different model and just say, listen, you get 5 years within an age defined period of time. Okay, so it's not 5 in 5, which is the thing that people say they want, like instead of 4 in 5, 5 in 5. It's not that because it's not that you can show up at college at any time and then compete for 5 years. The idea behind the new rule would be that your eligibility starts at a certain period of time, roughly correlated with when people enroll in college, and it ends 5 years after that. And there's not waivers, there's not exceptions, except for some limited ones that we think are probably legally necessary. This is just the period. So I think it would look a lot more as the example I gave earlier, Little League or U18 sports or U20 sports, where we just say there's this window when you can compete in college sports and be a college athlete. And for everyone, that window is going to end at a defined time. And it's probably going to be about the same time for everyone. It's ultimately the decision for the membership to decide if they want to go forward with this new rule. It's in the process. People are discussing and debating it, and we'll see where it goes after that.
And so the what at least has been publicly announced and discussed is that clock starts either at your high school graduation or your 19th birthday, whichever comes earlier. And and then you get you can compete for 5 seasons in that 5 year period if you want. There's already been some pushback from hockey associations, the NHL, claiming that doesn't really fit our system. We have guys who go to play junior hockey, so they don't get to college until they're 20 or 21, and this is cutting off half of their collegiate career. And I know that's been heard by the NCAA, and that's a membership decision. But is there a fear that if you do this rule, then this rule will be subject to lawsuits claiming that the old rule, when you had more flexibility, which led to all the lawsuits, is a more fair system and is a less restrictive alternative?
Look, I hope that doesn't happen, but I've been doing this for a long time. As you said, you and I have talked a lot of times in the past. And I think one common thing that occurs in the world is that when you change rules, inevitably there's going to be people who think the old rule is better. And so they will say, I like the old rule better than the new rule. And this has been a consistent issue for the NCAA over the years. One of the things that kept coming up in the compensation litigation that ultimately resulted in the House settlement is over the years, there would be efforts by the NCAA's membership to provide new benefits to student athletes, more snacks, more different kinds of funds, more travel stipends, what have you. Then every time you allow something new, people in the past say, oh, wait, I didn't get that. I should sue to get that. I don't understand the impulse. Again, I said, I short of Congress stepping in and acting here to give some cover to what I think everyone agrees are pretty common sense rules, I don't think there's a single person who would agree with the idea that there should be no rules on how long you can play college sports. I think you recently had on one of the lawyers representing the athletes suing us over the 4 and 5 year rule. And he was like, no, a 6 year rule would be crazy. Okay, someone else might sue for that if not you. But setting all
Like
that aside,
5 minute abs.
yeah,
Something about
exactly.
can't
Yeah, I
can't
wish
get a
they
good
were.
workout in six
I,
minutes.
I wish they
Yeah.
worked out, but if there were five, then maybe I wish there was a 4 minute version. None of those are working for me right now. But that's just a long way of saying, look, there could well be litigation. I think one of the things you try to do in making good rules and advising on good rules is think about, do we feel good about where we were? Do we feel good about where we're going? And if both of those things you feel good about, then the chips will fall where they do if there's actually a lawsuit that's filed.
Yeah. Okay. Thank you. Last quick question. You and I have talked about this a fair amount offline, but the Sports Broadcasting Act has been held out there as the silver bullet for all that ails college sports. Can you explain why it may be more complicated or is more complicated than simply amending the SBA to add college sports within its coverage?
Yeah, we could do a whole
Yeah,
discussion
that'll
of
be
just
appearance
that
number
topic.
7. Yeah, yeah.
Look, here's what I would say. I think the SBA has been around for a very long time. And it arose in the very specific context of the NFL wanting to figure out in the 1960s a sensible way to broadcast rights as a league. And at the time, the NFL was seeing that when individual teams were going out and selling their rights in the marketplace, it was not really working from a league perspective or from a competitive balance perspective because teams like the New York Giants, and I believe this is the case, it's very hard to believe these days for a variety of reasons, and I can say this because I'm from there, but even the Cleveland Browns, I think, had success selling their rights in the marketplace because they were the iconic franchise back in the day. Now, they were probably iconic for different reasons, but some teams were succeeding and some teams were struggling. And the idea was, what if you let us as a league have our teams agree with each other to put their rights together essentially into a pool, right? Put them all together in one group. And then we as the league will go out and negotiate with broadcast networks. This is an important component of it, broadcast networks. And the deal was you get to pool your rights together. And you then get to negotiate with entities that will put those rights on broadcast television, which at the time was free to everyone. Like all you had to have was rabbit ears, and you can still just have rabbit ears. And that's what the SBA covered. And as you said, now there is this idea that if we just allow college teams to pool their rights in an SBA type structure, there will be way more money out there in the marketplace and everyone will be on a level playing field and all this good stuff. And I would say I'm somewhat of a skeptic of that just for the following reasons. The first reason is part of the reason the SBA structure worked is that there was agreement among the teams in the NFL to do something that was collectively best for the league. This actually came up. We had a trial last year involving the Sunday ticket product that the NFL has. Jerry Jones, the owner of the Cowboys, testified. And a big part of his testimony was this it was saying, we decided that I don't know if he was part of that group, but he was talking about the league generally. We decided that we would be stronger if we pooled our rights together and went out in the marketplace, even if that meant some of us took a step back. It's no doubt, there's no doubt that the Dallas Cowboys would make more money than other teams or most other teams if they sold their rights themselves, but they thought it would be better for the league as a whole if they did that. A question is whether you have that type of spirit within college sports. Would all the big leagues decide that it was in their collective economic interest to put those rights together and sell them as a group to networks? Second component of this, at the time the NFL kind of struck this bargain, I think it's fair to say the media model was not really super successful for anyone. We now live in a world where leagues have gone out in the market and sold their rights, and some of them make a lot more money than others. That's just a fact of how things have developed. So, again, that goes to the question of are all those people going to be willing to kind of put that back in a box and start again and say, even though right now I have a revenue advantage over someone else, I would give that up? Like, I think the NFL model, there's no question, is like the most successful media model in sports. I think every league would like to have the model they have, but it came from an initial insight of doing things together may be better than others. And it came from an insight of let's do what's best for our league as a whole. And I just am not sure if you can get people to agree on that same structure when you have what are effectively different leagues that have negotiated different deals and now then need to kind of come together under one umbrella. And then I guess the last note I would just give on this is it's like conceptually a little odd to me that on the one hand you have the SBA being sold as like a solution to college sports, and on the other hand there are now apparently potentially investigations into the NFL for the way its media model is operating for maybe costing too much money. These things kind of go together, and so it seems either you like pooling or you don't like pooling, but there are sometimes consequences of pooling in terms of people being able to go in the market and sell their rights for a little bit more money than they might be able to otherwise.
And as you mentioned Sunday Ticket, just because the NFL and the pro leagues have the SBA doesn't mean that all of their TV deals are immune. It covers free over the air broadcasting. That's because that's all that existed at the time. But part of the effort was to make sure that the games are on free television. And if they're not, then it doesn't mean that the pooling arrangements are illegal on streaming or on cable, but they are not immune. So they need to be defended. And then the other piece that even if they did pool the rights, the other piece, and the SBA doesn't require this, but the NFL said we want to pool them and then share that revenue equally. And
Exactly.
that's the talk that I've heard is even if they do pool the football, college football broadcast rights, they wouldn't share the revenue equally, which might defeat the purpose of it. And what it really leads to is exactly what, as you said, Congress is looking around and the Department of Justice is why are consumers paying such high prices? They're paying such high prices because there are these pooled deals and the streamers are paying a lot of money for it. And so they're charging consumers a lot of money for it. And that may be a choice. Yeah, that's what we want to do. We want consumers to pay more money to fund college sports, but that's not the way they're looking at it right now for the NFL. So I agree. It's weird that one on the one hand they're saying maybe we should repeal the SBA, and on the other hand they're saying hey maybe we should expand it to include college sports.
Yeah, the point you made is a really one. Many points you made are good ones, but one of the ones that really stands out is the equal revenue sharing is like really the thing that has made the NFL so successful because everyone in the league views themselves as in this structure together, and so they've gone out and they've negotiated their rights. Now, look, I'm not sure I necessarily agree with the premise that it costs a huge amount of money to watch a season of NFL football. I think
Yeah.
it can cost money if you want every single
Right.
game, if you want your local games, and then you want some out of market games, and then you want Sunday night games, and you want Monday night games, and you want all the out of market games on top of that, then yes, there can be a cost associated with that. It's also the only league model where you can get a ton of content by just putting a box on your television and streaming it out there. Again, there's puts and takes to every model. I think I'd be a little surprised if Congress thought it was a good idea to basically give a group of leagues, the college sports leagues, broad antitrust immunity for anywhere they might put their games, regardless of how much it might cost.
Yeah.
But even setting that aside, if they were willing to do that, I do think the things that make the NFL so successful, from my perspective, are the things that it would be hard to force into the college sports model, given how history has evolved over the last 20, 30, 40 years.
Yeah, and it's interesting. There are just two quick related final points. One is, I think you and I have talked about this, but there is a sense in the public that we all have a right to watch every NFL game. Wherever we are in the country, we should be able to watch it for free. And that's the fact that people want to watch these games wherever they are and feel like they need to watch them is part of why the NFL is doing so well. But it's not as it would be great if I, as a Game of Thrones fan, could say, "Look, I don't want to have to pay for HBO. You should put Game of Thrones on NBC." Now, I get it. Game of Thrones is not a group of competitors, but putting aside the antitrust argument, that there's an understanding that we might have to pay to watch to get access to certain shows and certain premium content, but there's this sort of revulsion to that idea if it's a sporting event. I just think it's interesting, and then at that same time, for some college sports leaders to say, "Hey, I think it'd be a good idea for all of us to come together, stop competing, and raise prices to generate more revenue." That's a tough sell, I would think.
Yeah, and I think to your point, it is true that if you look at it from the perspective of someone who only wants NFL content,
Yeah,
getting Netflix for that one game costs an additional 19.99 or 21 or whatever Netflix costs these days. But you also get a lot of other stuff that comes with that, like
yeah.
all the other content. And so it's to me a little bit of an odd way to look at to attribute the entire cost of an entertainment service that I'm sure I would bet there's 5 people in America who use Netflix solely for the purpose of watching NFL games. So it's a little odd to say that's the cost of an NFL game.
And if you're in the local market, even if it's on Netflix, it's
Yeah.
going to be on your local channel for free. So
Yeah.
there is, yeah. All right. We've gone way over whatever time limit that I had said, but this is what happens when you're on the sixth time. It just
I'm happy that you still find it interesting to talk to me in the sixth
all
time,
rules
like as
are
opposed to the podcast getting shorter.
No, this is great. Thank you as always. I know it can be challenging to talk about cases that are still going on, so I very much appreciate your willingness to educate us all and to clarify the issues. And I hope the boat ride goes well. I assume that's where you're going with the Miami Vice jacket. If there's a
I might need a boat. It's downpouring here in DC, but
yeah.
no, I don't have anything so fun planned, unfortunately.
All right. Thank you. Good luck with all of your things. And I'm sure you'll be back on in a couple of weeks, maybe tomorrow, maybe
That's the
we'll
thing.
have you
If
back.
you hold a record, you got to keep as long as you're active. You got to keep trying to make the record higher.
You do. You're the Barry Bonds of this podcast.
Minus the steroids, I think.
Yeah.
But
Yeah. Yeah.
yeah.
Allegedly. But all right. Thank you, Rakesh. I really appreciate it.
Thanks, Gabe. Good to talk to you.
Yep. You too. Thank you.
And thank you for listening. And thanks as always to our loyal sponsor, the Tulane Center for Sport. See you next time on SportsWise.